Hi, this is Dr. J. Franklin Schultz with the Police Perspective. Today I want to talk about the Daniel Penny case, and as you recall, this is the young man with the Marine background who was on a New York City subway. And in the car entered another individual who began acting erratically and literally threatened to kill people on that subway car. Men, women, children, people of all kinds of diverse backgrounds. If you've ever ridden on a New York City subway, you know what I'm talking about. And this young man decided to step up and do the right thing and protect those other innocent people by restraining this individual. So I'll call him a suspect. That's a law enforcement term. I want to make sure that you understand that this guy's a civilian, right? He decided to restrain this individual, and during the process of the restraint, the individual died. Now, it's not really clear to a medical certainty that the type of restraint that Mr. Penny used was the direct cause of the individual's death. And of course, the other question that was posed before the jury is whether that level of restraint was necessary, whether it was negligently applied, or whether it was over applied. So there are a lot of things to think about, which is why the jury took so long in making the decision. Now, most commentators that I've seen who have some knowledge of what happened, and there is plenty of evidence of actually what happened, will say that charges should never have brought. It was a clear case of defending a third party. Now, in self-defense, a claim of self-defense, you can make that claim for defending your own safety or defending the safety of a third party. So the rules are the same for a self-defense claim. So a couple of things I want to talk about, and one of the reasons I want to talk about them is because police officers face this same kind of scrutiny. And another essential thing that we need to think about is if we're going to prosecute this young man for doing something which in most people's view was clearly the right thing to do, are we going to discourage other people from engaging in proactive, protective activity against an adversary who is threatening and poses a danger to others? Now, this has been called an act of vigilantism, and that's absolutely not true. This is a case of self-defense. Daniel Penny did not go onto the subway looking for bad guys. That would be the vigilante kind of attitude. This person came into his world and began to utter threats and behave in a way that made those threats very, very credible. So the precedent that's set by prosecuting this young man is to discourage other people from doing the right thing, stepping up and engaging in a perfectly legal, legitimate right to defend one's safety, self, and property. Now, the fact that this individual died, let's talk about that. Many times in cases like this, particularly when somebody's under the influence of drugs, they're not a healthy person. Their body is not in a normal state. And so when they are agitated, when they are aggressive, that means that their body is under stress, their heart's beating, their lungs are operating at the maximum capacity, and so there's a tremendous stress on the body, which in and of itself can have a fatal result. And then you add a struggle with another person, amps that up considerably, and so the direct cause effect, you do the restraint and the person dies. It's not just an on-off switch. So I want to talk a little bit about what was described as a chokehold. Now, I don't know exactly the mechanics of what Mr. Penny did, but I'll talk about the law enforcement side, because law enforcement officers undergo the same kind of scrutiny. And we expect them to be highly trained. And here's what happens with a neck restraint is we cushion and protect this part of the anatomy, which is sensitive and not very well guarded. A lot of the protection anatomically is on the back of the head, the nerves and muscles and those kinds of things. And so the front of the neck is vulnerable. And so we protect that part, and we just compress the vascular structure on the side of the neck, which can cause, it's intended to cause, temporary unconsciousness. Now, I don't know if you did this when you were a kid, but I did, where you spin around and breathe heavy and somebody squeezes you from the back and you kind of lose consciousness for a minute and then you come back to. That's the intent of a legitimate neck restraint, one of which is called the lateral vascular neck restraint. So that's legitimate, and it's very helpful, and it's used when you have somebody that's highly agitated. You don't want to shoot them. You don't have some of the other force alternatives, and so this can be a very effective and humane way to restrain somebody who is acting violently. Unfortunately, it has been branded as a chokehold, and when applied improperly, can cause the kind of distress that is associated with a lethal outcome. But it is essentially as safe as just about anything in dealing with a violent subject. But because of the bad publicity, a lot of departments have said, okay, chuck it, we're not even going to do that anymore, which is really sad because it's an effective hold. And you can debate with that with use of force experts. And in terms of the actual anatomical, biological, physiological result of a properly applied neck restraint, the safety of it, particularly in light of a violent offender where you're going to have to restrain them and protect others, yourself and others around you, then it should remain a valid option. But for many agencies, they've just taken the easy road out for the administrators, not easy for the officer that still has to deal with the violent behavior. So now exactly the mechanics of that Mr. Penny used, because as a Marine, you're trained to kill. You're trained for lethality. But here's the question. If we're restraining somebody, the moment that they maybe stop resisting, do you suddenly stop the restraint? Because if you stop the restraint, the person may start that same behavior over again, and you just restrain them again. The other question, particularly for a civilian practitioner like Mr. Penny, what exactly is the right amount of pressure and the right amount of time and the whole safety aspect? There are just too many variables to make a precise calculation that I'm going to hold this restraint for X number of seconds, and then I'm going to give them a second chance to get up and start the fight again. I think Penny did absolutely the right thing in the right way for that circumstance. And the jury apparently agreed, and in fact the prosecution agreed because they dropped the most serious charge. Now, I will say that he's not out of the woods yet, because you have to have proof beyond a reasonable doubt, which is a lot of proof in order to sustain a criminal conviction, but you only have to have a preponderance of evidence, just more likely than not, to prove in a court of law that Mr. Penny was negligent in the way that he responded and the way that he conducted the restraint and those kinds of things. So he's still going to get sued, and hopefully he'll prevail in that as well. If there's a well-informed jury, he will prevail. It doesn't mean that he's not going to continue to go through a life-altering kind of thing. And of course, the commentators who are racial justice warriors and see everything through a racism lens are going to say, well, he was white, this guy was black, therefore it was a race crime, therefore it was a lynching, it was vigilantism. And those kinds of activists who are misinformed about the history of what real lynching and real vigilantism is, are going to continue to press for persecution and prosecution of this young man who hopefully will be regarded in history as a hero and will encourage others not to overreact, but to react to a legitimate threat and to come to the aid of their fellow citizens. A significance of this is that, again, because police officers face very similar things, similar challenges, that it's hard to separate when a civilian makes a decision to use force and a police officer makes a decision to use force. A police officer is expected to have a lot more training and experience and to have this expertise, and they know exactly the right amount of pressure, exactly how long, exactly the circumstances, and all those kinds of things. Let me tell you about the variables in a use of force incident. You have not only the physiological limitations of a police officer, but also the physiology of the person against whom the force is being justifiably used. You've got the interested audience that you have to be concerned about. For a police officer, they also have to be concerned about retaining all the weaponry, because you don't want somebody getting your flashlight, getting your radio, getting your gun, getting your nightstick, getting your taser. So you have to be aware of all of that weapon retention. You have to realize that you have a responsibility, a mandate to take action. Penny could have sat there and hoped to God nothing happened. A police officer can't do that. They are impelled and authorized by law to intervene. Not to mention all of the sensory things and the stress and the limitations that humans have in terms of absorbing all of the information from all of the five senses. And at the back of their mind, they're thinking, am I going to get sued? Is this constitutional? Am I doing this technique the correct way? It's just a very complex set of decision making, which is why we need to give some latitude, not carte blanche, but some latitude for the officer's discretion, who in that particular moment has their best understanding of what the threat is and what the appropriate response is in order to make everybody safe and hopefully to get the suspect into a court of law so that this can be looked at objectively by the criminal justice system. But in the moment, it is literally a fight for life with all of the things that, unless you have been there, you cannot fully understand. And sadly, many prosecutors, juries, and judges are not presented with all of those facts because they're just looking at a video which only shows this much. Body-worn cameras have been a great boon to police officers. They're great evidence. They show that cops do the right thing the vast majority of the time. So they've been great for law enforcement, but they still only show a limited perspective. You don't get the smells, the sounds, the grunts, the tension, the spectators. Is somebody coming to help this guy? Do you have backup coming to help you? All of those literally millions of sensory inputs and thoughts that are going on during a use of force incident. And again, this young man, I think, did the right thing. It's sad that he had to go through this. First of all, that he had to take this action because this person was in a place where he shouldn't have been doing things he shouldn't have been doing. But also through this whole criminal justice process, and it'll continue through the civil justice process, and hopefully it comes out okay, and that he's not bankrupted, that he doesn't have to go into hiding like Darren Wilson had to do after Ferguson. So just wanted to make some commentary about that to bring some clarification. It's not a political issue. It is a legal issue only to the extent that we understand that people have the right to defend themselves and others from violent actors, and to do so using the best information they have at that moment, and their experience that they have at that moment, and their heart that they have at that moment.